This lecture asks, what is a personal data breach? What personal data breaches require notification? When must individuals be notified? What information does the supervisory authority require? How quickly must a data breach be notified? And I'll discuss preparing your organisation for personal data breach reporting. So, what is a personal data breach? We can define a personal data breach as a breach of information security leading to the destruction, loss, alteration, unauthorised disclosure of, or access to personal data. This definition means that a personal data breach is considerably more than merely losing someone's personal data. When do you have to notify the supervisory authority of a personal data breach? An organisation need only inform the supervisory authority, i.e. here in the UK, the ICO, of a personal data breach when that breach is likely to result in a risk to the rights and freedoms of individuals. The idea is that such a personal data breach, if it was left unaddressed, is likely to have a significant detrimental effect on those individuals. Examples where notification is necessary include discrimination, damage to a person's reputation, they might suffer a financial loss, loss of confidentiality, or they might suffer any other significant economic or social disadvantage. This means that the impact of a personal data breach must be assessed case by case. Let's say your organisation got hacked, and this resulted in the loss of customer data records. If the information contained in those customer records meant that, for the individuals concerned, they could suffer a financial loss, then yes, you would need to notify the data breach to the supervisory authority. On the other hand, say an internal staff telephone list vanished. Unless there was a real risk to the people on that list, that wouldn't meet the notification threshold. The key point is your organisation needs to determine case by case whether the personal data loss is significant enough to warrant notifying the supervisory authority. Where there's a high risk to the rights and freedoms of an individual, an organisation must notify the individuals concerned directly. What does a high risk mean? It's up to the organisation to determine what constitutes a high risk. But in informing the supervisory authority of a data breach, they might demand that you notify the data subjects directly, overturning your organisation's original risk rating and decision not to inform the data subjects. For example, say an attacker publishes or sells stolen online marketplace usernames, passwords, and purchase histories. The UK ICO considers this scenario as high risk, requiring notification. Let's say your organisation does suffer a notifiable personal data breach. What information are you required to submit? Well, the supervisory authority wants you to provide as much information as possible. Typically, this includes the categories and approximate numbers of individuals concerned with the breach, plus the categories and approximate number of personal data records concerned, the name and contact details of the data protection officer, if your organisation's got one, or other contact points from where additional information can be obtained. They'd also like a description of the likely consequences of the data breach. They want a description of the measures that your organisation's taken or proposes to take to deal with the data breach. And, where appropriate, they'd like to know about the measures taken to mitigate any possible adverse effects on the data subjects. How quickly do you need to notify the relevant supervisory authority of a personal data breach? A notifiable breach must be reported within 72 hours of the organisation's data controller becoming aware of it. This does allow an organisation some time to investigate a security incident and assess its impact. Even so, imagine if, as the data controller, you became aware of it at 5 o'clock on a Friday night, just prior to the weekend, immediately before a bank holiday. That could cause real problems. the GDPR recognises that it will often be impossible to fully investigate a security incident within the stipulated time period. So, it allows organisations to provide information in phases. If the breach is sufficiently serious to warrant public notification, then an organisation must do so without undue delay. If your organisation fails to notify the supervisory authority of a personal data breach, it runs the risk of penalties under technical non-compliance. Just to restate, this could result in a fine of up to €10 million or 2% of the organisation's global turnover. A sensible approach might be for your organisation to prepare for data breach reporting well in advance of it occurring. How do you go about doing this? Much of it is about promoting internal awareness, ensuring that all staff understand what constitutes a personal data breach, and that it's considerably more than simply losing some data. Organisations can establish their internal personal data breach reporting procedures well in advance. Doing this effectively requires a no-blame reporting culture. If your organisation has a blame culture, it'll be very difficult to assemble the required information within the stipulated timescales. An internal personal data breach reporting procedure aids an organisation's decision-making process for notifying the supervisory authority and/or whether it needs to go public about the data breach. Given the tight notification timescales, only 72 hours from the data controller's awareness, it's important that your organisation implements robust breach detection, investigation, and internal reporting procedures well before any such breaches occur. You wouldn't want to be simultaneously dealing with the impact of a personal data breach whilst also trying to figure out the required notification process.